Plaintiff applicant in this matter, Mr. LOHFELDT, appears in person.
Yes, Mr. LOHFELDT, welcome.
Good morning. How's everyone doing today? Great. I would also like to address the court. I, one of the family LOHFELDT, 8 people and sovereign, decreed as court of record in possession. The law of the case is common law. The law is decreed by the sovereign. I appreciate there is another opportunity to discuss this matter with NEDBANK. I think everything is in the documents. I don't know how much have you familiarized yourself with the files? Okay. Basically, there's much to say about banks and how they conduct their business. It's fraud under common law. The contract was fraudulent. There was no consideration. We can go through my affidavit point by point if we got the time. Last time I was quite ushered with the process, which ended up in me losing my home. And I hope you have also checked the news and see what's going on globally regarding finance and banking systems.
I don't pay attention to newspapers.
Okay. Yeah, no, I mean, I also do very, very little. That's correct. Okay, we can go through this affidavit point by point since I've made an effort of drafting it. What I think is very important, first of all, the contract, the alleged contract, which doesn't exist anymore because all contracts get destroyed as part of a securitization scheme. And NEDBANK has admitted after a diligent search that this original can't be produced. They also now admitted another affidavit that it's not even on their digital record, which is even more dubious. Basically, the fraud is the contract is fraudulent on its own because it needs 8 pillars or 8 conditions to fulfill a lawful contract. One of them is consideration. The bank has not considered anything. The bank has not given anything of value into this contract. That's a big thing which a lot of people, not including myself, have been asking in the courts. And we've also said if we can establish in a fair investigation, in a fair trial, that there is any lawful debt at the end of all these agreements, we're all willing to come to the table. What's also very interesting is that NEDBANK in this case is coming to the court and is bringing a claim. What is a claim? So they're claiming they suffered some sort of damages and loss. But if there was no consideration, no money was there in the first place to be loaned, but though they're still calling it a loan, that is fraud on its own. That is misrepresentation, and there's definitely no consideration. Because I have pledged to give my labor as a pledge to pay back any alleged debt, but the bank has not pledged anything. And they're also shrouding themselves in secrecy. They, I think, as per affidavit stating, it's a public company. If they were public, then all these documents would be ready to be accessible. Securitization register. Last time I've brought a notice for discovery. I've asked for the securitization register. I've asked for the original agreement and the actual accounting where this money, alleged money that I have received, which I actually haven't received, and where it originates. And I think it's a very simple, valid question. If you are under the impression you received something from someone, that it really is coming from that place. And basically, these questions can't be answered, and that alone, I think, should at least grant a trial. Now, we know from experience from the last 4 years, people not even being granted a trial, every time with the same excuse that these are unsubstantiated arguments, that we're just making this up, we're sucking this out of our tongues, and there's no justification to grant a trial because it's wasting the court's time and resources. We do know that when it comes to a trial, all this will be revealed, and it would probably blow the lid off, and it would be a massive scandal, which I also do understand that the courts and the banks trying to cover up. But someone has...
You want to be insulting to the court.
I don't want to be insulting to the court.
No, well, you are.
I'm not insulting you today. I've been here 6 times or 8 times.
Well, that may be, but you say that the courts are involved in the cover-up.
Okay, I'll take this off the record. I apologize. But from previous experience, I do have the indication that the judges I've experienced and that I've got to meet in the courtroom acting as agents for the banks. That doesn't include you at all. We have got transcripts, we have got documents.
Well, I can tell you now it doesn't include the courts, but you have to keep to the rules of the court.
That's correct.
That's what you have to do.
But the judiciary is supposed to be independent, unbiased, and objective.
Well, if we're independent, unbiased, and objective, then you have to keep to the rules. We can only work according to the rules of the law.
that is correct.
You can't do anything else.
Well, we have brought this as far as to the Constitutional Court. I've made complaints about judges,
Well,
and it seems
what
like,
happened in the Constitution?
well, the Constitutional Court, we filed a massive case last year that would
So
actually...
what happened? What was the outcome?
The outcome was the general stock response, the one-liner, no prospect of success.
Well,
That's,
so
but
that
is a sad response.
You weren't successful there.
I wasn't successful because I'm also alleging that the Constitutional Court as well is in with the whole syndicate.
Oh, I see.
And that's a huge allegation, and we made the Constitutional Court judges the accused in the matter, and they took a decision outside the court to dismiss the matter, which they actually shouldn't have. And I'm not the enemy of the court. I'm the enemy of the corporate state that has been corporatized, monetized, and capitalized, that is plundering and pillaging an entire country that has got wealth for everyone to live happily. And that is my main drive behind this. And this includes every mortgage, every vehicle finance, every credit card. And unfortunately, in our society, things revolve around money.
Then why do you enter into these agreements?
Why do you enter into agreements?
Yes.
Because first, that's always the same question we get. Because I was under the impression this was a legitimate agreement, but it turns out it wasn't.
So you're prepared to take the money?
I didn't take any money.
Well, it was advanced.
It wasn't advanced. That's what I'm asking NEDBANK. I said, can you prove you had the money in the first place? That's the problem.
What else?
What else have I got to say? You know, I can see it's going the same way again as we. I mean, like I said, it's always.
You may be probably right there.
Sorry.
You're probably right there.
Because unfortunately, I mean, we're getting some backing by other groups around the planet. It's a hard nut to crack, and I do understand this is a big, massive problem. I mean, there have been, for instance, I think P.J.J. Oliver, he was a High Court judge and also at the FCA. They drafted a 500-page document, Investigation into South African Payment System under South African law. Where all these things have been in detail described, how bills of exchange work, how promissory notes work.
Did you drive a Toyota Quantum?
That's correct.
You received it from them?
From Toyota.
From Toyota. Who paid for it?
Or NEDBANK now alleges that they bought this.
I don't believe Toyota will hand over a vehicle without being paid for it.
They received funds, fiat currency, created money out of nothing from NEDBANK.
Did they receive it?
From NEDBANK. But did NEDBANK have the money? Since digital banking, it's a miracle that all this money has been pushed into existence.
Yes.
And basically, well, that's also what, in some affidavit, there's another big issue that all these people who claim to be working for NEDBANK and some managers claim to have personal knowledge of this matter, which is absolutely impossible. None of them were around when I well, that's what they say. And I don't even know how far we have to take it and where to go with this. And at least there was a judgment at the Gauteng High Court on the 25th of May, which I've also added to the heads of argument, where Judge A.B. Rousseau, who is a newly appointed judge, only like I think starting this year, has exactly pointed out that a certificate of balance is no proof of indebtedness.
No,
Even if it was certified.
Proof of the amount. It doesn't create the contract. It only goes to prove what the indebtedness is. That's what it is.
And that is some number anyone can write up. So there's no proof that if it's a certificate of balance, only proves the amount. What is the amount? A fictitious number. Is it any debt? Was it created? Am I the creditor? Am I the debtor? Have I not created the money with my commercial signature? We've always been called credit debtors. We are the credit creators. We are the creditors in these matters, which is beautiful.
Yes.
There's nothing wrong with it. It just needs some transparency and openness. And this is what I said as well. If NEDBANK would be open, all banks would be open about this, we wouldn't be sitting here. And I've also, in the previous matter, which was brought to this court under case 1227, I've offered to settle. There are many ways to discharge and offset an account, not with cash. Cash is worthless in any case. There is a difference in between funds, fiat currency, money, monies, which most people are not even aware of. This is a debt slavery system, and I'm sure you're aware of this because everyone is living in debt. And I'm sure, I know, I've heard the argument many times, well, did you not have the money in the first place to buy the car? No, I didn't. So I thought there are banks who are conducting a regular business, they've got reserves, they've got money, they lend you some of their money, so you can afford something, you can buy something you can't afford. But when you find out shortly after that this is all based on fraud, I've been going to the commercial crimes unit, I've been going to the police, I've had meetings with Advocate Pochel from the, not the Hawks in Belleville place. Everyone kind of agrees to it, but everyone is not brave enough to do anything about it. Except maybe A.B. Rousseau, judge at the Gauteng High Court, who actually, which is almost a watershed judgment, has confirmed many things that we and other people have been arguing in any of these banking methods.
Yes, Ken.
Well, it's basically all I really have to say is there is no claim. There's also, I've had a preliminary convention as well, because at some stage I was fair enough and I said, okay, cool. NEDBANK created this money. So Joseph received 300,000 rands fiat currency, which is not worth anything. They're happy, they're glad. They got the car off their floor, received funds. I have paid back in the first 2 years, I think, something amounting to 100,000 rand. NEDBANK, on the very same day, created a note, a negotiable instrument, worth 300,000 rand. So there's no injured party, there's no loss. Everyone's happy. Why they're still here and suing me is obvious, because that scam would be revealed if they wouldn't. So everyone is happy. That note, even if this contract, alleged agreement, gets cancelled, the note still circulates. It's broken into thousands of pieces, into hundreds of securitization vehicles, making NEDBANK immense profit out of money that was never there in the first place. It's a great scheme. You have to give these guys kudos for devising such a brilliant method, which is actually quite simple. It even turns out that now it's not even sold at once. There's something called copyright derivatives, which means your signature gets copied and it gets multiplied. That this very document gets multiplied by 10 or 20 and put into various investment schemes. And what really irks me, that this is happening in a country where people live in abject poverty. If this was in Germany or in England, and it was done with some transparency or even secrecy, you could say people are well off. But here, this happens not only to me, a white guy who's relatively well off, this happens to people in the townships. Their RDP houses being taken away through the same method. And it's a very sad thing when you find out that the four major banks rake in 40 billion rand a month profit, only through securitization. No audit, no tax. You have to ask yourself, what is going on here? Where is that money going? Because not one penny goes back to the people. So at some stage, we have to bring clarity to this. And it's not the end of the banking world. It's not the end of the system. There are many people who are busy devising new systems, new ways of barter, of trade to come into place. Equal and transparent and fair to all people. And that's all I have to say for today. Unless Alan wants to say something else, I might reply to that as well. Alan is the representative for NEDBANK.
Yes. Well, I'm not sure if there's anything you'd like to say. Yes. Well, Lord, I've got two drafts. One only makes provision for costs, one for genuine client costs. Genuine client costs were not asked for in the particular. Just the normal cost.